Welcome to CASA Fresno Madera County's Advocate Academy training video. In this video, we're going to talk about court report writing. It's very important. Your court report is the way that you communicate to the judge about your observations on your case and what your recommendations are. So first, I'll answer some basic questions, and then we'll get into each section of the court report and what needs to go into it. So the first question is usually, why do I even have to write a court report? And so again, this is a legal document, and this is your way of communicating to the judge and all parties on the case about what your observations are and what your recommendations are. So there's different sections in the court report, and at the end of your report, you're going to make recommendations. A lot of times the judge will look at these recommendations and make the same recommendations, or the Department of Social Services will also have similar recommendations, or they might have recommendations that are not the same as yours. So the end goal is to have your report lead up to those recommendations. The next question is, when is my report due? If you want to stay on the good graces of your advocate supervisor, your report should be into them 60 days before your actual court hearing. They need a lot of time to look at your court report and make sure that if there's any missing information, they can communicate that back to you so you can gather the additional information that needs to go in that court report. Your very final version of your court report should be to your supervisor 30 days prior to your court hearing. Again, there's multiple steps that they have to go through to review that court report, and there might be a situation where there's information that you haven't been able to gather, and it's vital to the next hearing, so we really have to have you get that information so that we can include it in this court report. So ideally, 60 days in, you're getting them a first version, 30 days in, it's almost done, and then we want to file your court report no later than 3 days before the hearing. There are 3 important tips to remember as you're writing your court report. The first one is, we don't want to catch anyone off guard. So if something is going to go in your court report, you should have already communicated this to the social worker and potentially to the child's attorney. We don't use our court report as a gotcha. We don't want to put something in our court report where the social worker doesn't expect it or the social worker doesn't know something. Again, we want to be partners and we want to communicate with the social worker on an ongoing basis, so there really shouldn't be any surprises in your court report. The second tip is about giving kudos or a thumbs up when someone's done a good job. As you'll see, social workers have a lot of work to do, and it's a really tough job. So if there's ever a situation where you can say, hey, this social worker has gone above and beyond. They've been extremely communicative. They've really reached out and helped us get our job done. Then we want to say that in our court report so that we can lift that up to the judge and say, this person has done a really good job and we really appreciate it. The third tip is telling the truth. Sometimes we're going to have to communicate information that's the truth, but it's something that someone might not like. It might be something where a parent hasn't done what they were supposed to do, and you've observed that, and you don't want to upset the parent, but it's still really important to provide that information because it's the truth and it's factual. Another situation might be when a child has done something, maybe they aren't going to school and they got suspended, and you don't want to tell the judge that because you don't want that kid to get in trouble and have the judge say, why aren't you going to school? But again, you're providing information and it's the truth. It's important for advocates to provide all of the information to the judge, and the judge will do what they need to do with that information. Another important part of your court report is including our Journey of Hope methodology and the language from Journey of Hope. So throughout your report, there should be certain places where you're talking about Journey of Hope and the goals that you're working on based on your Journey of Hope guidebook. So there might be an example where you say that one of the goals from Journey of Hope and CASA is to make sure that this child is ready for college. So you might say in your report, my Journey of Hope guidebook says that this child should take the SATs to be prepared for college. And I've made sure that they're enrolled in the next test so that they can meet this goal through their process and their transition to adulthood. Okay, so let's get started. Let's talk about what you need to get prepared and ready to write your court report. So you should have received this court report guide from CASA, so have that ready. You should also have your Journey of Hope guidebook, because hopefully you've been taking good notes and you have information in your Journey of Hope guidebook that's going to go into your court report. So the first part of your report is the cover sheet. That's going to have your name, the date you were appointed as an advocate, the type of hearing, the date of the hearing, the children's names, their dates of birth and their ages. And it's also going to have the important professionals that are involved in the case, and they're the ones that are going to receive a copy of this report. So at the bottom of this first page, you should be listing which judge is hearing the case, who the attorneys are on the case, and who the social worker is. The very next section of your report will be the persons contacted. The very first person contacted in this list should be your CASA youth. Again, we want to list them first. They're the most important person on the case. After the children would be any family members that you've contacted. Your CASA advocate supervisor should be included in persons contacted because you should have been having a conversation with them along the way. The DSS social worker should also be listed because, again, you should be in constant communication with them. And then any other professionals who you've talked to and gathered information about the case. So this could include teachers, it could include the therapist or the clinician, it could include anyone that you've talked to about this case. In a situation where you have multiple kids on your caseload and it's not just one child, your report might look a little bit different. So it's important within each section to know whether or not you're going to give information about one child or multiple children. If you have multiple children, we should list them by age at the beginning of the report, and throughout the report, we want to remain consistent with the order of information. So if you have Johnny, Sally, and Billy, you want to make sure that in each section, you list Johnny, Sally, and Billy in the same order so that it doesn't become confusing as someone's reading through the report. The first section of your report where you're actually going to start writing is the case history. The first sentence of the case history should always start with, according to department reports. We weren't there when these kids were removed, but we have documentation of the situation. So we won't be saying that I observed this and this is part of the case history. We will be recognizing that this part of our report is usually gathered by someone else's information, which is the Department of Social Services. So again, the first sentence should be, according to department reports. In this section, you're going to talk about the initial situation where the kids were removed from their family. We don't need to go into great detail because everyone on the case probably already has those details. So we really want to just give a summary of what the situation was. The most important part is to list the actual count that was found true. Some of the pitfalls that advocates get into is they really want to paint a picture of what the situation was like. But at the end of the day, in the court system, a count was found true, and that's what we want to focus on. So if there were a lot of things going on at the time of removal, but the only actual count that was found true was a count of neglect, then we want to say that this child was removed due to neglect by the mother. We don't necessarily want to paint the picture of it was a dirty house and mom had been on methamphetamine for years and years. We just want to say the count that was found true. Also in the case history, we want to talk about any medical conditions that the child might have. Again, this provides a context for the entire report. We shouldn't wait till halfway through the report to mention to the judge or the other parties that maybe this child is autistic. It's important for anyone who reads this report to have that context as they read the report. Another important part is talking about the services that the parents are currently completing or they have completed and where the parents are at in this process. We should be stating in the case history, the case is currently in family reunification, or the case is currently in permanent planned living arrangement. Again, we want to provide some context for the rest of the report in the section that is the case history. Sometimes one of the last things we'll say in the case history is the whereabouts of the parents. Unfortunately, a lot of times in some of our cases, a father might be whereabouts unknown, and even a mother might be whereabouts unknown. So we also want to state that as early as possible in the case history. Some things we don't need to put in the case history. We don't need to say that it was a WIC 300 code. If the child is in the dependency court system, everyone knows that a WIC 300 hold was placed on the child. So we don't need to restate that in the case history. Another thing we don't need to state, but advocates sometimes do because it's in that original department report, is the name of the law enforcement official or officer that placed the hold on the child. Again, those are details that aren't necessary in our CASA report case history section. The next section of your court report will be the placement section. The first sentence in this section should be how many placements the child has been in up to this point. So you might say, Cindy has been in 3 placements up till now. In the placement section, we're going to give a description of the current living situation for your child or your youth. We want to make sure that we're describing the people that the child lives with, and we want to describe the home. So it might be that this child currently lives in a group home, and there are 5 other boys also in the group home. Or it might be this child is in a foster home or a resource home, and there's only 1 other foster youth, and maybe it's a single parent home. You can also talk about what the people do in the house. Maybe it's 2 working parents. Maybe it's someone who is a stay-at-home mom or a stay-at-home dad. So again, we want to paint the picture of what the environment's like for the child. Judges often say that this section helps them remember that this is really a child that we're talking about, and these are people involved. If the child has a pet, it's often an interesting thing and an interesting piece of information that they're not going to get from a social worker's report or from the attorney. But it's important for them to get that from the advocate because it's a good piece of information about what's really going on with the child, other than just the basic black and white facts. Another important piece of information to include in the placement section is a description of why the child has moved from placement to placement, if that's the case. You need to be very careful in this section. A lot of times we say a child keeps moving due to their behavior. This really isn't a good way to paint a picture of our kids, so we'd really like to see advocates describe that maybe the placement wasn't equipped to handle the child's behaviors, but it wasn't the child's behavior that caused them to move from home to home. This is a really important distinction to make because we want to remain positive when we're talking about our kids and the different placements that they've been to. Another important piece of the placement section is to describe how the child feels in this placement. Do they seem like they're comfortable? Do they seem like they enjoy living in this place? Maybe they're living with a family member and there's a lot of tension because of the family dynamics. It could be really important for you to provide your observation about those dynamics and maybe saying the child loves living with their aunt, but they have a really tough time when their mom and their aunt have conversations because they can feel the tension. And they've told me that it makes them really uncomfortable. Again, it's important for you to talk about the child and their perspective throughout your report, as well as providing your own observations and perspectives as well. The next section of your report is education and development. This section of your report might look drastically different depending on the age of your child. The first sentence of this report should always be who the current educational rights holder is. In the court system, if a parent isn't involved in their child's education, the court has the ability to take away their educational rights and give those rights to another person who will be involved with them. This is extremely important, especially if a child has special education needs. The educational rights holder is the only person that can legally sign the document that holds the school accountable for providing services to a child who has special education needs. It's very important that every time the education section is written, it says who the current educational rights holder is. In this section, you'll also talk about what grade your child's in, what school they go to, and what their academic progress looks like. You don't necessarily need to state their grades, but it's important to talk about how things are going for them when it comes to their education and their school setting. So back to the differences between the different ages. So you might be thinking, well, how am I going to talk about my child's education if they're only a year old or 2 years old? Again, this section is called Education and Development. For our younger kids that are 0 to 5, we're probably going to be talking more about their development and how they're meeting their developmental milestones. If you're working with a child who is ages 0 to 5, you should be helping or making sure that an Ages and Stages questionnaire, or ASQ, is being completed on a consistent basis. The information about the ASQ will go in the education section for your younger child. So you'll talk about, are they meeting their developmental milestones? If you have a 2-year-old, have they started to talk? Are they saying words? Are they starting to be involved socially with other kids their age? And all of that would go in the development section of your court report. When it comes to our older kids, you'll be talking about how they're doing in junior high or high school. And for our even older kids or young adults, we might be talking about their current status in high school, whether they're preparing for college, whether they're preparing for their transition out of high school, and how they're doing with their education overall. For school-age children, it is really important that as an advocate, you're in communication with their school. You should be talking to their teacher or teachers and really getting, again, their perspective about how that child is doing with their education. We encourage our advocates to go out to our kids' schools if appropriate, and again, observe one-on-one how they're doing and being able to report that information in your court report. The next section of your report is the health section. So this should have 3 different sections within the health section. The most important one, and the one you should start with, is mental health. As you've seen in other conversations and other videos, a lot of our kids are in therapy because of the trauma that they've been through in the foster care system or before the foster care system. So we want to start with mental health for each of our kids. You can talk about how often they're going to therapy, when their last therapy appointment was, who their current therapist is, and you should also be able to include in your report what their therapeutic goals are. So the clinician or therapist won't be able to talk about specific conversations that are happening in therapy, but they can tell us what the overall goals in therapy are. And as an advocate, you are able to support those therapeutic goals. It would be great if you could list those therapeutic goals in this section so that the judge can see what goals the child is working on in therapy. If there's a situation where the child isn't getting to therapy, maybe their foster parent isn't taking them consistently, this is one of those situations where it's an uncomfortable truth that you might have to raise to the judge, but it is an important factor, and people need to know that if a foster parent or a relative isn't taking a child to school, it's really important that they should be doing that. Another thing that you might mention in the mental health section is whether or not your child is taking psychotropic medication. There are a lot of specific laws around psychotropic medication. So if your child is on psychotropic meds, you've probably had a conversation with your supervisor, and they'll be able to help you with this section if needed. You should be able to list all of the medications that your child is on and the symptoms that those medications are treating. We don't necessarily want to put the specific diagnosis of our kids in our court reports, but we should be able to talk about the symptoms of their mental health or the symptoms of their behaviors and what medications are treating those behaviors. The next 2 sections within the health section are the physical appointments and dental appointments. So all of our kids should be getting what's called a CHDP physical every year. It's important for you to reach out to the doctor's office and verify that they've actually had that appointment. In your report, you might mention anything that was found at that appointment that might need to be addressed, or it might just say, no concerns were noted. The same goes for dental. Our kids should be seeing the dentist every 6 months, and it's important for you to give that information and say that they had their dental visit last week and no concerns were noted, or they had their dental visit last week and 6 cavities were filled. Again, this is very basic information, but it's important that we make sure that these appointments are held for our kids so that they can stay healthy. Another thing for our kids is glasses. If your CASA child wears glasses, it's important to check in and make sure, do they have the glasses that they need? Have they had a vision exam? A lot of times, unfortunately, kids break glasses, so it might be important to check in with the school and the foster parent and say, hey, I know our kid wears glasses. Do they wear them regularly? Do they need new glasses? So this is another important piece that you could put in your health section, is addressing their vision and whether or not they wear glasses. The next section of your report is the permanency section. The very first sentence of this section should say, the permanent plan is. We should always know what the permanent plan is for our kids. So it might be that the permanent plan is reunification with mother or father, or the permanent plan is guardianship with a relative, or sometimes, unfortunately, there isn't a permanent plan and our kids are just in foster care. The law has set up specific wording around permanent plans. So even if our children are in a long-term foster care situation and there's no real permanency, the permanent plan that we use is placement with a fit and willing relative. Basically, we want to make sure that that's the goal. We don't want to say that the permanent plan for any of our kids is just to linger in foster care. We want to always be pushing the system to find a real permanent plan. So again, if the permanent plan isn't reunification or adoption or guardianship, the permanent plan is placement with a fit and willing relative. Due to some of the struggles with our older youth, there's another permanent plan that was recently developed in the last few years. This other permanent plan is only for children who are age 16 and older. For those youth, they are able to have the permanent plan of APPLA, which stands for Another Permanent Planned Living Arrangement. This can be very confusing. If you have a 15-year-old, their permanent plan, even though they're still in foster care, would be placement with a fit and willing relative. As soon as they turn 16, the new permanent plan would be APPLA, Another Permanent Planned Living Arrangement. This allows some flexibility, and it reminds us that we need to be preparing for when this youth turns 18. If your case is still in family reunification, there should also be what's called a concurrent plan. There should be a plan B. If reunification fails, what is the next option? So your permanency section might say, the permanent plan is reunification, and the concurrent plan is guardianship with a relative. So we want to make sure that as we're headed towards reunification, we also have a backup plan. Because if reunification falls through and there's no backup plan, we don't want the system to be scrambling to figure it out at that point. So again, if your case is in reunification, you should also know what the concurrent or backup plan is, and it should be stated in the permanency section of your report. The next section of your report is the visitation and family section. The first sentence of this section of the report should say, the current visitation plan is. The visitation plan is the plan for how often or how long the visits are between parents and their children. So there's also a hierarchy and a progression of visitation. At the very beginning of the case, or if there's safety concerns, the children and their parents will be on supervised visits. They can also be on therapeutically supervised visits. This is where a social worker or a clinician will be supervising the visit to make sure it's safe for the kids. And this is also an opportunity for someone to coach the parents and hopefully improve on their parenting skills. The next step after supervised visits is unsupervised visits. So it could be that it's come to a place where everyone feels like it's safe for the kids to spend an additional amount of time with their mother or father, and so their visit is unsupervised. The foster parent might drop the kids off at the parent's house or at a restaurant, and they can have a visit with the kids for 8 hours. The next step in the visitation plan is a liberal visit. A liberal visit is up to 13 calendar days in a month. So this is a situation where we're feeling really comfortable about the safety and the ability of the parents, So we're actually giving a trial basis of the kids to go back and live with their parents for up to 13 days. Usually it's ideal to do a liberal visit during school breaks or vacation. So maybe throughout the winter break, we could set up a liberal visit where the kids will actually go home and live with their parents and try out how things are going. The next step after liberal visits are extended visits. So an extended visit can be up to 90 days. Basically, this is the point where everyone feels like the parents have made significant progress and it's safe for the kids to go home for an extended period of time. Ideally, at the end of an extended visit, the children will just return home and the case will be closed. Or at the end of the extended visit, they might transition back to what's called family maintenance. So the kids are basically placed back with their family and they're maintaining to see how things are going to go. Depending on the type of visitation that's going on, you as an advocate should be able to go and observe visits on your own. We want to be able to provide our input and again, our perspective on how visits are going. We don't have a right to be at those visits, but we're encouraged to go and observe those visits and provide that information to the judge. If there's ever a situation where a parent refuses or doesn't want you at a visit, it is their right to have that visit without you present. So please be aware of that and respectful of that. Another important part of the visitation and family section is addressing sibling visits. Kids are supposed to see their siblings, so it might be a really difficult situation because they're in different foster homes, but it's still important for kids to see their brothers and sisters. So it might be up to you to facilitate that conversation. And sometimes we have advocates who are the ones that transport kids to see their siblings. This isn't the ideal situation, and we would hope that everyone that's involved would also want to make sure this happens, but sometimes it falls on us to make sure that's happening. Another thing that can be discussed in this section is any other ties with any other family members. The department is supposed to do what's called family finding. They're supposed to do research and find any family members that are out there for these kids to stay into contact with. Unfortunately, a lot of times this isn't a main priority for folks, so it's up to advocates to try and make sure this happens. The next section in your court report is input for or about the youth. The first sentence in this section should be, "The child asked me to tell you." So this is a very important piece of where you as an advocate are literally telling the child, I'm going to go to court and I'm going to talk to the judge. What would you like me to tell them? So you should start this section with hopefully a statement directly from the child that you've been working with. This is also an opportunity for you to gather that information about the things that they've said and where they're at with this situation. A lot of times in the input for or about youth, we'll be talking about this child really wants to go home. Every time they see their mom, they're really sad after a visit and they really want to go home. This is a piece of information that you're providing directly from the child. If you have a younger child, then you won't necessarily be quoting them. So this might be your opportunity to give your perspective of how you think the child sees things and how things are going for the child. They might not be able to say directly what they think about things, but again, through your observation and your relationship with them, you should be able to say something about what you think they need. One of the last sections in your court report is the summary. Some advocates really struggle with this. It shouldn't be too difficult because basically you're wanting to summarize everything you've said up to this point. So what I would suggest is maybe taking a piece from each section and putting that in your summary. So just as a review, maybe you bring part of the case history in. These are why the kids are removed. And then you talk about what's gone on with their placement. And then you talk about their education so far. And then you talk about their family and how visits are going. And that should be your summary. At the end of the summary, if you want to make a statement and say that this is the information you provided and this is where you think the case should go, that would be great. And the last piece in the summary is if you really want to draw attention to something that you really want the judge to act on, it would be great to state it in the summary. The last piece of your report is the recommendations. This is where you're going to make very specific recommendations to the judge about what should be done for this case. We have some standing recommendations that will be provided for you. One of those is CASA should be included in all meetings. Another one might be that the CASA remain appointed to the case. Your recommendations should tie everything together. I would suggest when your report is completely finished, you read it backwards. So you start at the recommendations and see what you're recommending, and then go back and read your report and ask yourself, does this report logically lead to these recommendations? If that's the case, then you've done a good job and you can finish off your wine and be done with your report. If that's not the case, maybe you should take another look at it and really start with those recommendations and potentially work backwards so that your court report supports those recommendations based on your observations and the facts that you're providing. I hope this video has been extremely helpful, and I hope we've taken a little bit of the fear out of writing a court report. Please reach out to your supervisor because they really are there for your support along the way, and they really can be a help for getting this court report to where it needs to be.